There have always been conflicts between federal law and state law, but these days there's perhaps none more fraught with problems for employers than the legalization and regulation of marijuana. According to the Controlled Substances Act, marijuana remains a Schedule I drug, at least for the moment, alongside narcotics like heroin and LSD, and therefore a blanket federal restriction against it remains in effect. But it's now legal in more than half the states. So should employers be concerned about their employees getting high at work, especially if they're working remotely? Is drug testing in the workplace now a thing of the past? And what about that conflict between state law and federal law? We're talking about marijuana on the job with labor and employment attorneys Kristin Wedell and Shaka Sadler on this edition of the DMC Report.
From the offices of Dickie McCamey and Chilcote, this is the DMC Report.
As we speak, 38 states and the District of Columbia permit the use of medical marijuana, and 24 states have legalized it for recreational purposes. And according to one 2022 survey, nearly 1/3 of professional employees have used cannabis while working in the office or at home in the last 3 months. And the prospects for expanding the legalization of marijuana in 2024 in states like Florida and Pennsylvania seem likely. The Biden administration has already taken steps to reschedule cannabis from Schedule I to Schedule III of the Controlled Substances Act sometime this year, putting it in a much less restricted class of drugs. So what does this all mean for employers? That's the question we're tackling today with our good friend, employment law attorney Kristin Wedell from Dickie McCamey and Chilcote. Kristin has over 20 years of experience in the areas of business and labor law, civil rights, workers' compensation, and product liability, and is a certified specialist in labor and employment. And joining Kristin is her colleague, Shaka Sadler, also a labor and employment attorney who handles a wide range of complex employment matters. And Kristin and Shaka are joining us today from their office in Cleveland, Ohio, which happens to be the most recent state to legalize recreational cannabis. So Shaka and Kristin, good morning. Kristin, let's start with you. So how does federal law, particularly the Controlled Substances Act, intersect with various state laws regarding marijuana, right? What are the implications for employers that are operating in multiple states?
So as you mentioned, the Controlled Substances Act, which is enforced by the DEA, prohibits, marijuana use. It's a Schedule I substance, meaning no accepted medical use and a high potential for addiction, right? So, the federal law, it is illegal under federal law to consume marijuana. That's the way that they look at it. Now, under state laws, it may not be illegal, or it may be legal in some respects for medical marijuana versus recreational marijuana. So this is where you have to, if you're an employer that's in a marijuana-friendly state, then you have to look, at your policies and exercise caution when you're disciplining an employee, when you're, if you've got a workplace injury, for example, and you have a positive test for marijuana, it's not an open and shut case, right? You have to be careful on discharging an employee that just simply tests positive for marijuana because it could be off-duty use. And so there's more of an investigation that needs to be thoroughly done before you discipline or terminate an employee for things like that. Because, federal contractors are different. We talked about federal law and the Controlled Substances Act, but state law can be very, it's state specific. And so you have to look at whether it's legal for medical marijuana or legal for medical and recreational. So it's a lot more complicated.
So let's get down to brass tacks for employers. What steps should employers take to create and communicate clear policies, in the employment manual regarding marijuana use, both recreationally and medical?
So a lot of employers, if you had an outright ban for a drug-free workforce, I think now is the time that you need to look at your policy, right? And see if it needs to be changed. And I look at it, and you mentioned this before, we were talking about alcohol use, right? So Of course, it's legal for adults over the age of 21 to buy alcohol and consume alcohol, but an employer is certainly free to prohibit, an employee from drinking on the job and things like that, or showing up to work impaired, while under the influence of alcohol. So, when you're looking at the alcohol, you can alcohol use and impairment, you can still make the same analogy to marijuana use and impairment on the job. An employer doesn't have to allow an employee to consume marijuana and be impaired on the job just because marijuana is now legal in that particular state. One thing, in federal contractors side, or whether you have a federal grant, that comes into play, and there's different rules for that. But you really need to now look at your policies. Are you going to treat it like alcohol and offer like employee assistance programs and things like that? Now's the time to, if it's legal in your state, to look at your alcohol, your drug policies and see if they need to be changed, because you have to have a written policy. Like, we know that, we've been talking about that for years. You have to have a written policy. Now, it may not be clear because the laws are changing with respect to marijuana as to whether or not, marijuana is legal. The use of marijuana is legal on or off the job. Do you have to have is it legal just for, medical purposes or recreational purposes? How far is your policy going to go? And do you need to limit it based upon safety sensitive positions? So it's very particular. Also, what you need to do is make sure that your employees know what your policy is now. So in Ohio, where Shaka and I are located, Ohio has recently changed the laws, and now the employers are trying to craft policies that comply with the state laws and figure out and really communicate those policies to employees. Have a written policy, an addendum to your policy, have an employee sign it. It may be helpful to put together a frequently asked questions sheet and put on a little presentation, or encourage your employees to review the policy and come to you if they have any questions. Also, you have to train your supervisors now. If we're going to ban impairment in the workplace, which it's certainly something that employers are concerned about. What are the signs of impairment for marijuana use and things like that? Some of your training that was for alcohol may be applicable, but maybe not. So now's the time to look and see, do your supervisor need to be trained on what to do if they have a report or suspicion or something that an employee is impaired on the job for marijuana use, or smells like marijuana. There's all kinds of different things that you need to start looking for, and have your supervisors trained on that.
Got it. Shaka, let's turn to you on this question of drug testing. How does the legalization of marijuana impact drug testing policies in the workplace? Are there best practices that employers should be looking to?
Yes. So although most states where legalization has happened or is on the horizon, maintaining a drug-free workplace isn't challenged. However, facing workforce shortages and things of that nature, it may not be practical for a lot of employers. So in terms of testing and policy considerations, a lot of employers aren't mandated to have drug-free workforces or having employees that have safety-sensitive operations, federal contractors, things of that nature. They may want to reconsider things like pre-employment testing. It may not be necessary, and it may keep them from getting a ton of employees that would otherwise qualify and do a great job, but are prohibited because of those things. So like Kirsty was saying, going over those policies and seeing really what is necessary and best for the business, that in no way gives employees the right to come to work under the influence of any substance. But that is the general trend that we're seeing now, is employers going through and getting rid of pre-employment testing, pre-hire testing, and kind of leaning more towards reasonable suspicion.
So in states where it's legal, how can an employer balance the right of an employee to use cannabis recreationally while at the same time maintaining a safe and productive work environment?
So the best way to do that kind of balance is written policies. Really, written policies are king and best practice anywhere you go. Um, just laying out your expectations for them to come to work clear of mind and outlining that disciplinary action will be taken if they do come to work under the influence. Really, trainings are essential as well. Training supervisors, managers, in a way that they can identify reasonable suspicion and implement the testing according to that policy is essential.
So can you talk about a little more about the implications of marijuana use, in workplace safety, especially where safety is such a critical concern?
When we're talking about potential implications of marijuana and the use on, in the workplace, in areas where safety is a critical concern, like a construction zone or construction site, or when in a situation where employees are operating heavy machinery, these are where employers are concerned about the dangers of a workplace injury. I mean, these are certain, and these are safety sensitive jobs is what I call them. And so one thing is that an employer, they can lawfully refuse to hire an applicant if they're not, for a safety sensitive job, even if marijuana use is legal in that particular state. There is a heightened sense of concern, for employee safety, and rightfully so in a situation where, there's more of a likelihood of danger, or that the employee could be injured. They can discipline employees or discharge employees that work in safety sensitive jobs if they, use or test positive for marijuana, even if they have a medical card. So, but before you just jump the gun and say, well, everything's, a safety sensitive job, it may not be necessarily the case. And so you have to look at the essential job functions of what the employee's doing. So look at the work site in general, right? Are we talking a machine shop, or if we're talking, let's just say that we're talking about a machine shop. Are we talking about the employees that are operating the machines, or are we talking about somebody that's doing the paperwork in the back office? And that makes a difference. Are we talking about somebody that's using the phones, or that it's operating the phones or handling customers, at the front office? And so, so it's certainly within an employer's right to have a different policy for safety sensitive jobs. I mean, that's clear, and you do want to be proactive in creating a culture of safety so that people feel that they are, that they understand what the rules are, and that they also then, in turn feel comfortable coming to the employer, with, if there's a problem, if there is, if that employee is suffering from, or, some addiction or things like that, as Shaka was just mentioned, to having your policies in place. So look at your workforce, which could vary, state to state, location by location, and look at that particular employee's job function to determine, if the rules need to be different based upon a safety sensitive job. Because, certainly you want to make sure that if there is a heightened risk, that's being addressed.
Are there any emerging trends or recent cases related to marijuana in the workplace that employers really ought to know about?
Absolutely. Employers should largely be aware at this point that there are a ton of marijuana laws that are changing at a dizzying pace. And with those changes in acceptance comes maybe an increased use of the substance. So in fact, SHRM did a piece about this recently, and they had mentioned that a lot of employers are doing the policy reviews. They are spending the money to, conduct those trainings, and largely every employer should be doing the same. So not to further hammer on the point, but trainings are important, policies are important, but also understanding the laws that you're subject to are also important.
Have we discovered yet any unintended consequences of legalized marijuana in the workplace?
We actually have. One of the things that was kind of gently mentioned here was the uptick in positive testing after workplace accidents. So Quest Diagnostics found that a number of positive marijuana drug tests came back after workplace accidents at an incredible percentage. So there was a 204% increase from 2012 to 2022. So just think about that for just a moment. We have been dealing with this for about a decade, and a 204% increase in positive test results after a workplace accident is incredible. And I don't really see it slowing down from there. More and more states are just kind of jumping on the train to legalizing marijuana medically and recreationally. So I know I've said it a number of times, but it's too important not to say. Training employees or training your supervisors and managers to identify the signs of someone being intoxicated or under the influence while on the job is just so important. And workplace accidents aren't just left to, big industries and forklift folks and things like that. Workplace safety is up to every employer. So even if it's an office job, someone being under the influence can have incredible repercussions.
Yeah, and I'm sure the business insurance industry would have something to say about workers' compensation claims resulting from all of this, but that's probably a topic for another podcast. I guess my last question for both of you is, what advice would you have for employers dealing with conflicts between employees who have different views on marijuana use in the workplace?
So there is, very widespread disagreement on this particular issue, as with others. So, employees are free to agree to disagree, right? They can, express their First Amendment views on certain things, but for employers, the concern is when it crosses the line, right? And when does it cross the line? It crosses the line when it escalates into something that could be considered bullying or harassment and violates your anti-harassment policies. And I think that the biggest thing to be concerned about is, when you have a report of what may be considered harassment based upon use of marijuana or having, a medical card, you have to immediately conduct an investigation like you would any other complaint of discrimination, harassment, whatsoever. You can't just think that this is more of a lighter issue or something that, is not that, big of a deal, so to speak, right? Because if it's legal, then who cares in your particular state? You really have to watch because, we mentioned that states' discrimination laws could apply here. And if an employee has a medical marijuana card, which is legal in your particular state, and they're arguing with another, employee, and they feel that they're being harassed or treated differently because they're have a medical marijuana card for a disability, then it jumps into the realm of is somebody being harassed or discriminated against, treated differently by a supervisor or something along those lines because of their disability. So employees are free to agree to disagree, but you really have to watch when you have a report of something that could be considered harassment and violate your policy.
This issue is one that if it hasn't arrived in your business yet, chances are it's going to soon, particularly if you operate in multiple states. And it's going to mean big changes to your employment policies and your employment manual, to say the least. So we appreciate you taking the time from your busy schedules to sit and chat with us about this today. Kristin Wedell and Shaka Sadler from the Cleveland office of Dickie McCamey and Chilcote. Thanks again, ladies.
Thank you.
From the offices of Dickie McCamey and Chilcote, this is the DMC Report.